Welcome everybody to the first Ashcroft Mitchell McGregor webinar for this year. You have myself today and Shush talking about a workplace law update and what's on the horizon for 2026. So what will happen after the presentation is a recording of this will be available if anybody needs that, and you'll also get a copy of the slides that we've spoken to. In terms of what we're going to cover today, or actually let me just start with who we are. Here's a picture of myself and my partners, and we have people who are based around the North Island and helping clients around the country with all things employment, immigration and health and safety. So in terms of the discussion today, what we're going to be talking about is laws that have passed in the last year, legislation that's in progress or that's been signalled in terms of policy updates by the government. And I think it's fair to say it's going to be a heck of a busy year in terms of change in this space, just with what's in train already. And the government is left, right and centre making announcements about various things that they're saying they're going to be putting through before the election. And I expect, given the the timing of the election this year, that it's likely that we'll see much of the legislation that's in progress coming through fairly quickly early in the year. And then some more major things which need policy work and we don't yet have a bill, for example, around some of the health and safety guidance that the government's been talking about and around the Holidays Act are likely to be later in the year, is my guess, given the significant amount of consultation that has to happen on those. So I'll give you an update on all of that. We'll talk about a case law update. There's just a few cases to mention there today. Talk about trends that we're seeing in terms of workplace claims and where our regulators in these areas are focused this year, and give you some practical guidance as we go through. So it's going to be a bit of a whirlwind tour because there's a lot happening, but as always we'll try and simplify that as much as possible, and you can always contact us if you've got other queries after this. You're welcome to pop some questions in the Q&A and we'll make time for answering those at the end of the session as well. So without further ado, in terms of legislative change, we talked about the Employment Relations Amendment Bill in our last presentation, and so I won't go into detail about what the changes are that come under this heading, but just update you a little bit in terms of what happened at Select Committee stage with this bill and where we see it heading. So, and there's information about each of these changes on our website. We actually also have a running legislation changes table, which is available if anybody wants a copy of that, which we're updating all the time about where things are at. And so there's no shortage of extra detail if you missed the first update about this. First of all, the legislation or the changes that are covered by this bill include these four headings, and I'll just talk about what the implications are of each of these things. So first of all, the contractor gateway test. Basically, this is a good one for employers who want to continue using contractors as a mainstay of their workforce, provided that you're willing to meet the criteria that the changes or that the legislation lays out. So this law has been nicknamed the Uber law, and it's because Uber has really pushed for the case law, which says that all of its workers are employees and not contractors, to be addressed by legislative change, so that it has the freedom to operate using contractors under New Zealand law. So basically that's where the start of this law came from. It will be useful for a number of businesses. However, there are some provisos, including around freedom, that contractors must be allowed to be able to ensure that when you have a contractor agreement in place, it can't be challenged with people arguing that they're employees, just like has happened with Uber. And here are two of the things that you need to make sure that you have covered, as well as meeting the other criteria, which I won't go over. At the Select Committee stage, what changed was really minor. So basically, one of the criteria is that the agreement says that the person's a contractor, the select committee said, well, do we have to be specific that the person's a contractor? Could the rule just be that we don't call them an employee? And so that is where the bill currently is at. From a practical guidance perspective, I would say it makes a lot of sense to be clear that if you intend someone as a contractor, you call them that, and you're not then left having to argue about whether there's enough clarity over that. But basically, the bill has now stepped that back a little bit to say, well, it doesn't specifically have to say they're a contractor. I'm just saying I think that's still a really good idea. In terms of the next piece here, not really much change to this part at select committee stage. So this is looking to stop people who've got personal grievances where they've been terminated for serious misconduct from getting any remedies. So basically recognising that while they're to blame for the fact that their employment's ended because of their wrongdoing, so they shouldn't then be entitled to any compensation just because there might have been some technical downfall in the employer's process. So not much change at the select committee stage. This law, I don't think will move the needle a lot for employers, but these are the two tips once it's passed that I think employers will need to be across. So looking at definitions of serious misconduct and policies and agreements is the main one. The reason I don't think it will really move the needle is because we already have the ability for employees not to get remedies. If they've got a personal grievance and they've contributed to that, they're to blame for that. So I don't see this as a major win for employers. Next, and we're doing a lot of work in this space with employers who are engaging senior employees at the moment and looking at their employment terms to forecast for when this law changes. This next one, there was a shift at select committee stage to increase the threshold for access to dismissal claims so that it's now a $200,000 package, $200,000 remuneration package. Previously, it was a $180,000 salary only that people would have to have as a minimum in order for employers to be able to negotiate that they don't have access to personal grievance claims. So in terms of the work we're doing in this space, it's really about employers deciding, do we want to still allow our most senior staff to have access to PGs, or do we want to look at other ways to manage exits for them and exclude those rights? And so if you're hiring anybody in this space at the moment, my headline for you is give some thought to how you want to handle this as a business. And while you can't yet write out of agreements access to personal grievance, you can flag, particularly for negotiations with new employees, if you intend to seek to negotiate that when the law passes. And I would suggest forecasting what you might do instead in that case is a good idea. So for example, we're looking at including no fault termination clauses, which allow the employer to basically purchase an exit if you're going to be excluding personal grievance rights. That's one of the ways that you would work through that, and I expect there'll be a lot to do with senior employees for the 12-month transition period once the law passes on this front, for employers to align their strategy for the high earners with what employment documentation says. So this is on the to-do list for employers who have a number of employees in that category. And then finally, no changes to this in the select committee stage. This is just about unions and employees who join unionised employers not having to be covered by the collective agreement for the first 30 days of employment. This is a classic one government puts it in, next government takes it out thing that we see coming in and out of the law, depending on who's in power. So just that happening again under our current government. And you can expect that the Labor government would swiftly put this back in if they become government after the election. So this next one is about termination of employment by agreement, and this bill has been in play and working its way through the select committee process for quite some time, but we had quite a lot of change happening when this was reviewed by the select committee, and so I'll just update you in terms of where this is at. So in short, this bill is intended to allow employers and employees to be able to agree on exits without having to go through a formal process to end employment like you normally would. And so basically, I mean, I have to say at the start that we often are helping people have exit discussions, so helping strategize around how you set that up. This law would allow that to happen by agreement, but there's a number of criteria that would have to be met. And from a practical perspective, I think that strategic thinking through, is this the right type of conversation to be having? Do we think the employee is going to be open to it? What are we going to do if the employee declines to engage? All of those strategic questions will need to be worked through to decide if this is the best plan once this law passes, and I expect the law will pass fairly soon. So the requirements are that the employer has to basically request the employee to engage in the exit negotiation process. They have to give them reasons for that, tell them that they're allowed to get advice, allow time to get advice, tell the employee they don't have to engage. And then there's a limitation that a request can't be made more than once in 6 months unless there are, and this language which we already have in the Act, genuine reasons based on reasonable grounds to have the discussion. There are also some requirements around, I mean, if I look at the second bullet point, no misleading or deceptive conduct through negotiations, that's really kind of like a good faith duty extension. And then basically the rest of it is that if an agreement is reached, it acts as a full and final settlement. The termination agreement is the language they're using, would be in full and final settlement of everything relating to employment, and that those discussions can happen I'll use the term without prejudice. It's not technically without prejudice, but off the record, basically. So can't be brought in evidence if there's any future personal grievance claim when you're having negotiations under those circumstances. The bill also says that unfair negotiations can't happen, and that could happen where the employer knows that the employee is just relying on what the employer has told them, doesn't have capacity to engage in that discussion, or there's some other unfair inducement of them to have that type of discussion. So, I mean, this could be useful. It kind of formalizes what a lot of employers do at this stage anyway, but I still think it will be very much proceed with caution, be quite strategic about choosing to take this path. And if you are taking that path, of course, make sure all the requirements are met. And I'm sure that the courts, like they do with any exclusion to employee rights, will be reading those really closely to make sure that, like with trial periods, that all of the boxes are ticked if employers are looking to rely on this as something that can happen secretly and can't be raised in evidence about any other claim. So what else has happened? Well, last year, all of these laws passed that relate to employment, and I won't go over what each of them mean, but if you're not already aware of them, they really do need looking at. The kind of the last one on the list here, the KiwiSaver employer contribution increase, this kicks in 1st of April, and so the default KiwiSaver rate increases, and then there's further increases to come, and the next one is 2028, increasing to 4%. So there are, just to flag on this, you can still use total remuneration clauses to say that people who join KiwiSaver, any contributions the employer makes can come from the employee's remuneration, so that the person gets a whole package, and any money they're receiving in the hand is reduced if they join KiwiSaver, basically. Around a quarter of employers use these, and that is something that I know a number of employers are revisiting, thinking about how they're going to fund the increase. And people can also opt out from the higher rate contributions. So I think many employers are aware of this, and it's already something that's been managed at a strategy level in terms of what the plan is, just flagging that this is about to come into effect 1st of April, and there are a couple of options around how the cost of it might be managed, including using a total remuneration clause. More law changes to come. So these are things that aren't currently at the bill stage. The Holidays Act reform, this is a huge one for New Zealand. This will affect every employer with a payroll. at the moment, all we really have is the government signalling that it will make this change, and we'll have something called the Employment Leave Act. There'll be a huge amount of consultation needed on this because of the impact for every employer, and the bill isn't currently in play. It's still being drafted. So watch this space there. I won't get into my views on how this is looking at this stage, just in the interest of time. But that's what there's some information about what it looks like at the moment, but we need to see how a bill's set up in order to be able to really know what to expect. There is a members bill in play proposing changes to the Human Rights Act. It hasn't yet had its first reading. This one is looking at extending prohibited grounds for discrimination to include gender identity and variations of sex characteristics. That ought to be a fairly pan-political issue, I would think, and I would think that once this is introduced, that it will progress. So watch this space for that. And there's also a bill in play around restrictions on restraint of trade for people who earn up to a certain amount or don't work full time. This restraint of trade bill, though, has been just sitting there not going anywhere for a number of years since the Labor government. It was a private members bill from a member of the Labor government, and so it won't have support with the current government, I don't expect. So it's there, but we're not going anywhere with that right now. So watch the space on that front. There's been a fair bit of media coverage of the modern slavery legislation that's been introduced as a bill to government, and including about the various political alignments to get that introduced. There were actually two private members' bill that had different suggestions about how we tackle this that had been introduced late last year. And so watch the space in terms of how this progresses, but at high level, here's a summary of what that's about. In short, New Zealand is really behind in terms of having modern slavery legislation. The modern slavery changes that have been proposed really are for only the very largest companies in New Zealand. It'll be entities with consolidated revenue of over $100 million, including overseas companies that carry out business in New Zealand, and basically means that they need to check through their supply chain and everything about how they're operating to make sure that there's no exploitative labour practices happening anywhere down the supply chain, and report on that. So I think the thing is that question mark over support that this will get at government, and there's a lot of detail in the media about that just this week, actually. Who will it impact? Sure, it's targeted only at our largest entities, but if you're a supplier to our largest entities, then probably you'll need to be across some compliance with this, because they'll be wanting to make sure, that's the whole point, is that everybody who's part of their supply chain is doing the right thing in terms of making sure there's no exploitative labour practices, and they'll be reporting about that. There's also an extensive enforcement regime here. So this is about New Zealand addressing issues like human trafficking, which most other countries, Australia included, already have covered in law. So we're a little late to the party. I think this will progress in some shape or form, and I think that it will affect more businesses than you might think, looking at who's required to report under the bill, just because of the interconnectedness in New Zealand, and the fact that there are often a lot of smaller businesses who are actually doing work alongside the larger businesses, so will be subject to some kind of compliance. And also, I suppose some people might like to adopt some of the practices as a demonstration of good practice. So in terms of trends and what we're seeing in the employment law space, increasing number of privacy claims coming to light. Definitely pretty much all personal grievance claims that I see these days have a privacy request component, and if the privacy request component isn't taken seriously or addressed in accordance with the Privacy Act, there's a whole other progression of claim that can happen in the privacy space. And there are some new decisions coming through the Human Rights Review Tribunal about privacy breaches, with some pretty significant awards for hurt and humiliation, compensation for people who are affected by interference with privacy or breach of privacy. I think there's also been a fair bit of commentary recently from the Privacy Commissioner saying, as the Privacy Commissioner always does about these things, our privacy laws are not strong enough. We need some more teeth in terms of forcing compliance. People treat privacy like an afterthought in New Zealand, and commenting on some of the data breaches that have been publicised recently, like with Manage My Health, for example, and what the approach is to addressing that. And so I guess I would just flag that when it comes to our people strategy, addressing privacy and making sure that we're across what our obligations are, that we have the right policies, that our managers are trained on privacy obligations, is all pretty crucial as part of our employment or our people risk management. And we have certainly been doing a fair bit of training for businesses to assist with that and providing policy documentation as well as helping with privacy request responses. So I'm happy to talk more about that if that's a hot topic for anybody. Human rights claims are also being progressed more often, I think, including there was a case in the last year or so about sexual harassment where the person who'd been harassed, who was an employee, didn't take a personal grievance claim but pursued the person in the business who had sexually harassed them as an individual, which is an option under the human rights legislation. And the Human Rights Review Tribunal is pretty generous in terms of its awards, especially compared to the Employment Relations Authority. So seeing more cases going to the Human Rights Review Tribunal, also on the discrimination front. And this is something to be aware of, just in terms of the way that we're managing these areas of risk in our business, because employees can pick their path. Do they want to take a Human Rights Act claim? Do they want to take in a personal grievance claim? And the Human Rights Act claims are becoming quite popular, particularly because of the tribunal's generous awards of compensation. In terms of health and safety breaches, the reason I've mentioned this in terms of it being an employment law trend is because most of the personal grievance claims, like with privacy requests that we're seeing all the time, will also mention that the employer has breached health and safety duties by not providing a safe workplace, including in terms of people's mental health when they're pursuing a claim. And this is because of a case where large awards were made for people who had not been looked after in terms of health and safety, had ended up with PTSD. The Melville High School Cronin Lamp case is what I'm referring to. So basically that allowed a lot of remedies for people who had suffered as a result of a health and safety breach. And now we're seeing people looking to be quite creative about why they're claiming remedies and what remedies they're claiming. And yeah, this is a very common thing to be raised in personal grievances now. So I do think that having a combined health and safety and employment strategy and making sure that things like psychosocial risk are covered in health and safety management, but that people leaders understand how that connects with employment obligations, is crucial to managing risk on this front. So moving now to case law, and we've just got a few cases here. The first one is just to let you know that there was a decision in the Supreme Court case with Uber, which came out, I think it was November or December last year. This is not so important in terms of what does it mean for me, because of the contractor gateway law that we've already got in play and is progressing. But basically, the Supreme Court agreed with the Employment Court and Court of Appeals findings that Uber drivers in New Zealand are actually employees and not contractors, and basically reaffirmed our current legal principles around this, which I've added in some detail here. In short, it's still a live issue for people who are using contractors to consider that those contractor agreements can be challenged, with the person arguing, well, I'm really an employee, even though my agreement says that I'm treated as a contractor. And the court is pretty sympathetic to that. And so again, if you're a business who relies a lot on contractors, you should be considering risk to date, I would think, with those, and preparing for the legislative change and deciding, do you want to meet the criteria that are set around the contractor gateway test, or do you need a different strategy around how you're going to be engaging people once that law passes? Because if you don't meet the criteria provided by the contractor gateway test, people will still be able to come to the court like they are at the moment and argue that I'm really an employee. So that avenue is still open if you haven't met all the criteria for the test once the law passes. So the next case is about an employee who was working for the Reserve Bank. This person, there were a number of issues in terms of how she was engaging with others at work. She was working on a fixed term basis, and she then sought to resign from her role early after she had been applying for other work and used her manager as a referee, and then was told that she wasn't successful in getting the other work because of the reference. So she reacted angrily to her manager about that, and then ultimately sought to leave her job early. But the issue here was really about how the employer had addressed her behaviour. And so she raised a personal grievance claim because the employer had invited her to a meeting that was called like a check-in meeting, and said that it was to talk about her well-being, and described at the meeting that the relationship had broken down. And so she, after that, felt like, well, I actually can't carry on here. And I've been called into this meeting and I've had no chance to have support, and raised a personal grievance claim around that and around the impact for her, not being able to come back to work and finish the end of her role, due to what had happened with the wellbeing meeting. So I think this is quite an important one for employers to note. I mean, the facts here include that the person had some mental health challenges that she had shared with her employer. And so I think, it's fact specific, and you need to deal with the person as they're kind of showing up at work. But the main thing for employers is, well, give some thought to, is this a meeting that I can have one-to-one with the person, or is it something that I should allow them to have support at? And frankly, I would have generally said, if you're not proposing to do anything in terms of like taking any action with the person, that you wouldn't normally need to allow a support person. But the court's saying, well, look, in this situation, the person wasn't told what the meeting was about in a truthful way. She wasn't allowed support, even though the employer should have identified her as being a bit vulnerable there and a bit heated about what had happened. And the meeting was of quite a sensitive nature. So at least she should have been allowed a support person, should have been told what the meeting was actually about in advance. And then there's another criticism too about the employer saying that the relationship had broken down, which, is probably perhaps taken out of context. I mean, that language saying that the relationship's broken, I would think is potentially predeterminative of an on-the-record process, but the employer wasn't even trying to run a formal process. It was just trying to talk to this person about what had happened. So it's really a signal that the court is saying, look, you need to consider what the particular needs are of your employee in the circumstances, and make sure that you're accommodating that as much as possible. So hot tips are, give some thought to whether the person should be allowed a support person or representative, and make sure that in framing the reason for the meeting that you're being upfront about that. Would be the two main things. She was awarded $12,750 for compensation for hurt and humiliation. She went all the way to the employment court. That's a long way to go, and an expensive process for an award of that level, but just signalling, I suppose, that there is some sympathy for that type of claim at court level. So something to be aware of. Last case I've got for you is about WorkSafe. and what had happened here with an improvement notice that had been issued. Basically, this business had a management plan in place around how it was dealing with a particular material, and the particular material was a gas rather than a liquid substance. WorkSafe said, you're not doing this right, you should treat it like it's a liquid substance, and issued an improvement notice. And the business said, no, you don't understand. It's much safer for us to treat it like a gas because that's what it is. We shouldn't treat it like a liquid, and it would not be safe for us to comply with the improvement notice and sought to have that set aside. So this is quite rare, and quite rare that there has been action taken by WorkSafe successfully set aside. And the reason we're talking about the case is just because sometimes I suppose the WorkSafe approach is one that does need to be pushed back on firmly by the employer. In this case, they had to bring their own expert about what the safest way was to handle things. But they were successful in having the improvement notice set aside. So I guess getting that expert support at an early stage to back the employer's position is one of the key things that could be kept in mind if there's if WorkSafe's taking a particular tack which feels completely wrong to the employer from a risk perspective. So that's a novel outcome. Moving on in terms of health and safety updates, just briefly here, in short, the government says, look, we're going to make changes to the Health and Safety at Work Act, and we're going to make it easier for employers to comply with the Health and Safety at Work Act. We're just going to focus on the worst possible harm that could happen, and that's where our resource will be spent. And we were expecting changes late last year, but to come into effect this year. And these are some of the things that had been kicked around by government in terms of options. However, we actually haven't seen anything in terms of legislative change. These are very high-level policy comments that have been made by the government, but with no real depth behind them at this stage. Just in the last day or so, the government has come out saying, oh, well, we're going to tell WorkSafe that it should focus on lower level enforcement options rather than pushing for prosecution, and indicates, I suppose, we're trying to be supportive of business, but in terms of details about how the legislation is going to change and what employer duties are going to change, we have a real question mark over that and haven't seen any depth. So one of the questions we have, I suppose, around what's been signalled, the government is basically like, look, we're going to have smaller businesses just be focusing on the basics and not doing things like managing psychosocial risk or mental health. And we have a question about how that might actually translate in terms of a law change when we've already got a lot of employment law cases where that type of harm, like mental health harm, if you like, has been considered by the authority, by the court, and assessed with awards made for breaches of duty. So how, given that employment law and health and safety law are so intermixed, how might the government split out dealing with psychosocial risk from what is already a lot of employment case law? Question mark. But really we need to watch this space in terms of the draft bill, which is, I mean, there's not really a time frame around when that might come. In terms of the WorkSafe focus, there certainly is still a focus on directors and officers and personal liability. And we had the CEO of the Ports of Auckland who was held personally liable in the last year or so. There's also cases where WorkSafe is pursuing individual directors beyond companies having gone into liquidation, which is really going further than you would normally expect with the protection of a limited liability entity. We have increasing penalties. There have been some record fines issued, and there's a couple of examples here, and penalties at a large level where there's serious situations like Whakaari, White Island, and I have to kind of wonder about what might happen with some of the some of the situations like at Mount Maunganui recently on this front, and what the approach might be there as well. High risk industries in focus, these are the latest industries that WorkSafe has signalled it's really looking at in terms of manufacturing, abattoirs, food processing, and is focused in the infrastructure sectors as well. What we're seeing in terms of the prosecutions is that while the legislation doesn't specifically say you have to document everything, it's much easier, of course, to demonstrate that you're doing things right if you have got some documentation that shows that. And this is quite important in terms of demonstrating that you've taken reasonably practicable steps to ensure health and safety when you're in a defence of a WorkSafe investigation or prosecution situation. And proof that training's happening, proof that risk assessments have been carried out and are updated regularly are all important on that front too. We're seeing more awards for reparations for emotional harm as well as physical harm. And corporate accountability post-disasters is still very much a focus, with WorkSafe keen to shift the needle at the leadership level, and to address anything that's like a systemic failure, which is I think why we see the focus on the multiple PCBUs, and then looking at everybody who could possibly be involved with things like whakaari. There has been a change to the drug and alcohol framework with a standard that has changed. There's a transition period for this. Basically, it's around lowering the levels of various substances that can be detected in testing. And so the new standard will need to be used from December this year, but many employers are already using this, and TDDA have already got testing in place to test at the lower level for the new standard. So it's actually optional, I suppose, for employers to decide which standard they use while we're in this transition period. And then after that, all employers will have to use the new standard, which will mean that drug and alcohol testing policies and practices will have to be updated by the end of the year. So there's also kind of a question around, well, what type of testing should we be using? And TDDA offers both urine and oral fluid testing. Which one should employers be using? There's quite a lot of discussion around the fact that oral fluid testing is less invasive than in terms of privacy than urine testing. Just generally speaking, there's an impact depending on the type of test for detection levels and timeframes that the substance has been in the person's system, so that has an impact. And the general guidance is that oral fluid testing can be used for post-incident or reasonable cause testing, but otherwise urine analysis is better. So, for example, for pre-employment testing, you wouldn't normally use oral fluid testing. But this is something that needs consideration in terms of what this means operationally. How are you doing your testing? What type of testing is being done? What are you trying to achieve in terms of the testing? And what are the safety considerations? So I guess the only other thing that is very much a hot topic, given the amount to which it's being prescribed now, is medicinal cannabis, and policies need to be updated to account for that and what that means in your workplace. Very high level. Basically, our testing doesn't really look for impairment. It just looks for whether a substance is there or not. So some employers are looking at other things in terms of being able to assess impairment. There's generally a requirement about reporting of use of medicinal cannabis if you have a drug and alcohol policy in place, like with other prescription medications. And you know, it's a risk assessment piece as far as whether that's something that you can allow in the circumstances or not in your business. So your policy should deal with that if it doesn't already. The WorkSafe enforcement policy has been updated. This is, you know, the latest that's coming out from the Workplace Relations and Safety Minister about wanting WorkSafe to be more helpful as a regulator and not just to be focused on enforcement and prosecution. So she has told WorkSafe that they can issue pre-charge enforceable undertakings. They can also issue formal warnings rather than, so giving them a bigger toolkit with some softer, lower level options than they have previously been using. So that is our overview in terms of employment and health and safety, and I will now hand over to Shush, who's going to talk about immigration changes.
Cool, thanks, Kate. I'll just take control of the slides and move the slides along. Um, so the immigration landscape of New Zealand continues to shift, and as employers and people who work with migrant workers, it's important to have a good understanding early of these changes to help protect businesses and support migrant workers and a migrant worker workforce. So I've started off these slides with information on the Worker Protection, Migrant and Other Employees Act. Um, the key message under this act is the penalties are very low. Um, there are three triggering offences for a penalty. They are in essence: one, allowing someone to work who isn't entitled to work; two, employing a worker inconsistently with their visa condition, and that's a very wide penalty offence that immigration like to use. And then three, failing to supply documents to authorities within 10 working days. For companies, each breach can trigger a $3,000 infringement fine per worker. And the bigger thing for especially larger employers is the employer will be placed on a public stand down list, and they'll lose the ability to support new AWV workers for AWV work visas. They'll lose the ability to support their current migrant workers for residents under the any of these sort of skilled pathways like the skilled migrant category and so forth. So it's an important piece of policy that immigration has been using. I'll just move along with the slides. So INZ has publicly committed to auditing at least 16% of all accredited employers annually, and a lot of the fines and investigations that we see are raised under the Workers Protection, Migrant and Other Employees Act offences. Um, for the 2025 year, um, Immigration New Zealand reported as a successful milestone having raised 151 of these types of infringement offence notices, and they have proudly set out that um, they've raised at least $520,000 in fines. So this is an area that we believe immigration are going to continue to target and focus on and take a hard line approach to. So I've just got some case examples here of what we've seen employers get or have an infringement notice fine raised for. So, for example, we're seeing some employers who have committed very what we think are minor errors have an infringement offence notice raised against them. So, for example, accidentally paying an accredited employer work visa holder $25 or $27 instead of the rate on their accredited employer work visa, which might be, for example, $29.66 per hour. Immigration New Zealand still treats that as a breach. Um, and just the takeaway here is that I guess employers should check the conditions on the accredited employer work visa for all of the accredited employer work visa holders to make sure that, you know, even accidentally, let's say for a month or a period of time, that the accredited employer work visas paid less than what's required. Um, the second sort of type of sort of case that we've seen quite frequently is where employers move their accredited employer work visa holders around, and then as a result of that, that breaches the location condition on the accredited employer work visa. So, for example, let's say you've got a accredited employer work visa employee, and they work they're supposed to work in Auckland and they're moved to work in, let's say, Wellington or Queenstown for 2 or 3 months, then if immigration identify that, they could raise an infringement offence against that, because it would be technically considered a breach of the location condition on that accredited employer work visa holders accredited employer work visa. I guess takeaway here is small mistakes or breaches can have large consequences for employers. Now, with these sort of types of breaches, we have had some success with having infringement offence notices revoked, especially when it is in respect to just accidentally paying a worker um, just a little bit less than what the accredited employer work visa sets out, but it's something that we don't recommend leaving to the event of an infringement offence being raised. We strongly recommend having audits completed to make sure that an infringement offence isn't raised against the employer in the first place, because no one wants to be publicly shamed on a stand down list. Moving along. Um, Here I've got some high-level immigration changes and considerations in respect to the maximum period of stay, and these are quite. In essence, what this policy is and what the general rule is that accredited employer work visa holders can only be in New Zealand for a set amount of time of either 3 or 5 years. So for skill level 4 and 5 roles, the general rule is that an accredited employer work visa holder can only be in New Zealand for 3 years, and for skill level 1 to 3 roles, an accredited employer work visa holder can only be in New Zealand for 5 years. Once the worker reaches their maximum period of stay, either 3 or 5 years, then what they need to do is leave New Zealand for 12 months, and then, in essence, afterwards they'll have the ability to apply for a further visa. Now, one of the sort of exceptions, and later on we'll touch on this, which is the recommendation that if you do have workers who are, let's say, skill level 1 to 3, and they do have the ability to apply for residence, we recommend starting to look into this now, because if for example, worker obtains a New Zealand resident visa, then the AWV maximum period of stay requirement won't apply to them, and also potentially the government have indicated that they might give some leeway in terms of, let's say, a worker is only short a few months, and up to potentially 12 months to apply for residence, in terms of, let's say, um, getting or gaining the last sort of 3 to 6 months needed for them to be able to meet requirements, then there might be some wiggle room there. Um, but just going back to sort of what's on hand instead of going on a tangent with residents, just with the maximum period of stay, um, it's quite relevant because the accredited employer work visa category was introduced in around 2022 and opened at that time. The sort of 3-year mark, if workers had been supported for visas from, let's say, 2023 onwards, is 2026. So it's quite relevant now to start looking at your workers, if you have any that work in skill level 4 and 5 roles. And for skill level 1 to 3 roles, accredited employer work visa holders that have been supported from, let's say, 2022 onwards, 2027 isn't too far away. Time flies, and 2027 will tick over technically in a year's time. So even if you have skilled workers who are working in skill level 1 to 3 roles, we also recommend starting to look into providing support to help transition them to obtaining residence. Because if it gets to a point where they don't have the ability to apply for residence, or some of these exceptions on the slides don't apply, then they'll need to leave New Zealand for 12 months. So I'll just talk to some of the exceptions. Now, this is only, these exceptions generally are only for skill level 4 and 5 roles here, and it only extends, for example, the 3-year maximum period of stay, the 3-year maximum period of stay period to 5 years. In essence, the exceptions are if the worker submitted their first accredited employer work visa between 21 June 2023 and 6 April 2024, and were paid at least 29.66 at the time their AW was approved, then instead of being limited to a maximum stay period of 3 years, the skill level 4 or 5 worker will be able to stay in New Zealand for 5 years. And the other exception there is if the worker has a pathway to residence. So, for example, for some of the care workers under the sort of work to residence pathway, they have a pathway where they can stay in New Zealand for 5 years if they meet requirements to apply for residence within that 5 year period. For skill level 1 to 3 workers, the 5 year maximum continuing stay period generally is a hard rule with potentially only a sort of 1 to 12 month in future possibility of staying a little bit longer, and that's if new policy is introduced, which the government have indicated that they're looking at. Where let's say you've got a worker who's skilled and they're just a little bit short of meeting residence requirements or need just a little bit more time to meet English requirements. But I guess as a takeaway, and just summarizing this slide, the takeaway would be to start looking now at your workforce, your migrant workforce, and then complete an audit to plan out when maximum period of stay limits are reached, and to look at whether any workers can be supported for residence if you want to extend their employment in New Zealand and support them for residence. I'll just move along from this slide. Here now to help with residence planning and so forth, there are some relevant residence changes this year, and the biggest one will be the introduction and expansion of the skilled migrant category to open up, in essence, two new pathways, which will be a skilled work experience pathway and also and a trade and technicians pathway. I'll just briefly summarize the sort of core requirements under these two categories. So firstly, under the skilled work experience pathway, this is for employers or migrant workers who work in skill level 1 to 3 roles. Now, there'll be a new pathway where instead of needing to hold, let's say, a bachelor's qualification or be paid 1.5 times medium, the worker can potentially meet requirements just by having 5 years of directly relevant work experience. Now, in regards to work experience, at least 2 years needs to be in New Zealand, and it needs to be paid at a rate of 1.1 times the median wage rate. So currently the median wage rate is around 33 and $56, and so the 1.1 rate will be higher than this at approximately, let's say, $36. So that will be positive news. Now there might still be changes to this policy because the government have also indicated that they'll introduce an amber list for, in essence, which is a list of roles where instead of being required to be paid 1.1 times the median wage rate, the migrant worker might be required to be paid, let's say, a higher rate of between, let's say, 1.2 or higher times the median wage rate. So this is a point where the government still haven't finalized their changes, but it's still good news that they've introduced a skilled work experience pathway to help migrant workers who don't meet requirements for residence currently, to give them an option to potentially meet requirements later on this year. The second sort of subcategory, which is the technicians and trades pathways, requires migrant workers who work in skilled sort of technician and trade roles. This pathway provides them with a pathway to residence if they have a level 4 or higher qualification that's recognized by NZQA, and if the worker has at least 4 years of post-qualification experience, including 18 months of work experience in New Zealand, at or above the median wage rate. So this one doesn't work with a multiplier of the current 33.56 median wage rate. And will allow your migrant workers who do work in trade and technician roles who have a level 4 or higher qualification that's relevant to their role and is recognized by New Zealand's NZQA, and who have at least 4 years of post-qualification work experience to potentially apply for residence. So that is quite positive news for employers with migrant workers in New Zealand, because this will potentially allow your migrant workers within a migrant workforce to stay in New Zealand for longer and for their employment to be continued beyond, let's say, a maximum continuous stay period. Um, so so that is, positive news. And then I guess on this topic of residents policy changes. The government have indicated this year that sometime around March they'll make a decision on whether they'll increase the residence wage threshold. So, for example, with these new changes in August, for example, with the skilled work experience pathway, there is reference to, requiring workers to be paid 1.1 times the median wage rate. Now, that might change. After March this year in terms of what the skilled median residence rate is. So at the moment it's 33.56. After March, this could also increase to $35 per hour, but this is a point of uncertainty and it's just something to bear in mind and watch out for later on. Now, the good news on this point is that this will generally only apply to new migrant workers who are coming into New Zealand. So the government have set out that migrant workers who have already started in skilled roles and who are already working, their skilled median wage rate can be calculated from when they started work and not from when they applied for residence. Um, so that is that will hopefully help, but it's still important to keep in mind that the skilled median wage threshold will potentially be increasing in March this year. The overall takeaway from this slide is that employers that employ migrant workers should identify if any workers have a maximum continuous stay period that will apply to them and potentially look to support them or test their residence eligibility or make this recommendation. And this could potentially help with those employers with retaining their sort of migrant workforce in New Zealand. There will be some other changes also that have been sort of earmarked for this year. The first one is INZ is expecting to expand deportation liability rules for resident and temporary visa holders. This will also include, for example, so currently with deportation liability, it only triggers through convictions. Well, this is sort of what the position was previously. Now, the government have expanded this to trigger if a person pleads guilty. Now, the relevance of this is if a person pleads guilty but is discharged without conviction, then previously under the sort of prior setting, deportation liability wouldn't trigger, but under this new setting, it would still trigger because they had pleaded guilty to a sort of an offence that potentially triggers deportation liability. And the relevance of this is that so if you've got migrant staff who have resident visas and permanent resident visas, then if they do get into trouble with criminal offending, then they might be at risk of deportation liability and having their visas still cancelled. So this is just something to keep in mind this year. It will be a bit of a change to the status quo from previous years. Second thing on the slide, which is in regards to the national occupation list. So the Immigration New Zealand have already indicated that they'll transition from ANSCO to the national occupational list. And the relevance here is that for accredited employer work visas, job check applications, and residence applications, the current status quo is still to use ANSCO, which determines skill level. Now, in future, and there'll be more news on this year, the government will transition to using the National Occupation List, which is a different list, and that might change, for example, whether, for example, a role is skilled or not, because some roles will move from being skill level 1 to 3 to 4 and 5, and vice versa. So it will be positive just to keep an eye on this. The last relevant sort of point of change that we anticipate or might see this year is the possibility that the government might introduce a levy like what is run in Australia for migrant visa holders. So, for example, in Australia, employers, in addition to supporting, let's say, a job check and a career employer work visa, they also have to pay $1,000 approximately per year for every year that a migrant worker works for them. This is something that potentially might be announced this year and might need to be factored into future planning, as it might increase sort of the cost of labor / employing staff and migrant workers. So just keep this in mind. I think that's pretty much all in terms of the immigration changes. I think with the current immigration setting and the adjustments and calibrations, the practical advice is just to keep on top of these changes and to plan ahead, because they will be happening this year. Back to you, Kate.
Yeah, thanks, Josh. I think that actually takes us to questions. If anybody has any, if you do have questions, just the Q&A is where to pop those in the chat. So, Shush, I'm not sure if you can see those. Let me just go to these.
Yep.
So, can you see the question from Studi there? Do you want me to read it out?
Yeah. So there hasn't been an indicative levy quantum released yet. I've sort of just taken the $1,000 mark from what is used in Australia by the equivalent of Immigration New Zealand Australia. I think we'll just see further news on this this year, I think, if the government choose to implement it. The actual piece of legislation that they've used or that they've sort of that they're using is the Immigration Fiscal Sustainability and Systems Integrity Amendment Bill, and that gained royal assent last year. So the legislative power is there, and it's just a question mark of whether the government want to use that power, but they haven't set a quantum for the levy. But if they do, we'll definitely put out some information on it. Thanks for the question. It's a great question.
All right. Well, look, thank you so much for joining us for our webinar today. There are a number of other sessions that we'll be holding through this year, including to update on the changes that we see coming. Shush and I and all of the team are very happy to answer any other questions if you want to get in touch directly after this. And if anybody would like a copy of that legislation table that I mentioned, feel free to ask and we'd be happy to send it out. Thank you so much for joining us.